Hey, everybody. Welcome to today's Law of Self-Defense show. 2 or 3 minutes later than scheduled. Sorry about that. Was a little bit delayed in getting a few things in order in preparation for the show, but I'm very glad that you all are here. For those of you who may be new, I am, of course, Attorney Andrew Branca for Law of Self-Defense. Wow. What an interesting, fantastic welcome. I can't tell you how much I appreciate it. Before we dive into things, the usual reminder, if you are not yet a subscriber, we are just a couple of dozen people away from 42,000 subscribers. If you're watching this on YouTube and that subscribe button is red, that's wrong. It needs to be gray. So pound that subscribe button until it turns gray. Hit the bell to make sure you get notifications. Smash that like, thumbs up button. And please leave a comment. I don't really care what the comment is. The comment is intended to trigger the YouTube algorithm into spreading our content more broadly. So even if it's just your city and state, a hello, whatever the case may be, if you are currently a consumer of our books, courses, whatever, and you'd care to say nice things about those, that's always appreciated as well. But all of that helps us to get our content, our mission out to more people out in the community of law-abiding American citizens who we feel need this information if they're going to be capable of lawfully defending their family, themselves, their property, and be hard to convict in the process. So, I have to make a confession before we start, and that is when I first looked at the content for today's topic, which is this Kansas Supreme Court decision, which has been heavily reported as meaning that police officers who injure a bystander in a use of force event do not have the benefit of self-defense when they do that. I knew right away that was a misinterpretation of the law. I assumed that the media, as usual, was mangling the applicable legal doctrines. And it's true, they did continue to mangle it a bit, including, by the way, the reporting in the ABA website, ABA being the American Bar Association. So an optional private organization for lawyers. You'd think they would get the legal stuff right, at least report it correctly, and they didn't do that. I'll share one of their articles with you in a moment. So the featured image, the thumbnail I used for today's show, strongly suggests that the media here just screwed up again, and they did. They got things wrong. But much to my chagrin, when I dove into the actual court decision, the Kansas Supreme Court did a pretty good job of mangling the law all by itself. There was really no prospect that the media was going to be able to correctly report the law on this case, given what they were handed by the Kansas Supreme Court, which is pretty much a hot mess. That said, as bad as the Kansas Supreme Court applied legal doctrine, and they applied it very poorly, the media made it even worse. So it's not like the media is scot-free. It's not that they even accurately reported what the Kansas Supreme Court was saying. They still made mistakes, the media. But I am much more sympathetic to the media in this event than I normally am, because the Kansas Supreme Court did a poor job here. And by the way, folks, that should be a reminder about the dangers of getting into fights you don't need to get into when the legal experts can't get this stuff right. You really want to put your fate in their hands? And this is a pretty premier league of legal experts, right? It's a state Supreme Court. So these are people who were good enough for the appellate courts. They were good enough for the trial courts. They were probably somewhat esteemed lawyers when they were practicing law. So they've worked their way far up the legal ladder to become state Supreme Court judges. And yet they screwed this up in public, in front of everybody, in this very high-profile decision. And we'll step through how they screwed it up. So if even the elite of the legal profession can get this stuff wrong, you can imagine the risks you run when you place yourself just in front of a trial judge. because you used force, maybe in circumstances where you didn't really have to. Now, if you had to, well, then it hardly matters, right? If the alternative was you were going to die, your wife was going to die, your kids were going to die, well, then you use the defensive force and you just suffer the consequences, whatever they might be. And it would still have been worth it if you prevented you or your spouse or your children from dying. But there's not a lot of things that are worth putting yourself in front of a trial judge who may not be very good, other than that very short list of items. And I think we might be joined today by another lawyer from the LawTube group. He asked for an invitation. I sent him one. In the event something's come up and he can't make it, I'm not going to share his name because I don't want to embarrass him, but we'll see what happens as we proceed through this decision. Now, before we get to the actual Kansas court decision, whoops. Let me see. Let me pull up court decision so I have it pulled up. And I will share a link with all of you to that Kansas Supreme Court decision. But before we dive into the court decision itself, because it does such a thorough job of mangling the law that it can be frankly difficult to even explain how badly they got it wrong without first explaining what the law should look like. So just imagine that they were asked to paint, a rough drawing of a cow, and what they came up with looked like some mix between a shark, a pigeon, and a cat. Unless you know what a cow's supposed to look like in the first place, you may not understand how badly their actual image was as a representation of a cow. So let's first talk about what a cow looks like. Let's first talk about what the legal doctrines applicable in this case ought to look like. So just to give you the facts in the case as a starting point. So we had police here were responding. Several officers were responding to a domestic violence case, a man with a gun, and they entered the home where this event was taking place. The man with the gun was threatening people, threatening himself, putting the gun in his mouth. There were children present. They could be heard crying over the 911 call. So admittedly, a high stress call for service to the police. The police show up and they go into the home and they're doing their thing. And a pit bull, happens to be a pit bull, comes out of one of the bedrooms and advances on one of the officers. The officer fires 2 shots at the dog as it's advancing on him. And the shots, I believe they missed the dog. But in any case, one of the bullets fragments. And fragments of the bullet strike a young girl who was basically seated within the line of fire, so not far from where the dog was. And one of the rounds struck her just above the eye, not a round, a fragment. Another fragment struck her someplace else, I forget. But she suffered injury, could have suffered death. Clearly, might not have been a fragment, it could have been a full round, right? Which might well have killed her. But that was the injury she suffered from the officer who fired these rounds. And that officer would be charged with effectively felony reckless endangerment. And we'll go through what the elements of the felony endangerment statute are and so forth. And the officer raised the legal defense of self-defense, and he did it in a self-defense immunity hearing. So Kansas, where this occurred, is one of the states that has a self-defense immunity provision. And I'll go over this in more detail, but the best way to think about self-defense immunity is as a facilitated, more rapid, less costly way of arriving at a finding of self-defense than the traditional way. The traditional way to get an absolute adjudication on self-defense is to go through a trial, a full-blown trial. Then the jury gets instructed on self-defense. At the end of the trial, they deliberate and they return a verdict of guilty or not guilty. And if it's not guilty, presumably it's on the grounds of self-defense, the legal defense that was raised. And once they return that verdict, well, then we know from a legal perspective that was self-defense because the jury determined it to be so. But arriving at that final adjudication, the traditional way through a full-blown trial is extremely expensive. And of course, very risky. As I talk about often, if I have to put you in front of a jury, there's at least a 10% chance you get convicted, and I don't care how innocent you are. That's just the noise in the system. So what if there were a way to get to a final adjudication, a final finding, an absolute finding on self-defense without having to go through the hundreds of thousands of dollars of a criminal trial and all the risk that goes along with that. What if there are a way to have that absolute determination of self-defense made pre-trial, in a pre-trial hearing, before a jury's even selected, with the judge playing the role of the jury, playing the role of finder of fact? And both sides argue self-defense the defense argues in favor of self-defense, the state argues against self-defense, in kind of a mini trial that might take a couple of days instead of weeks, and for a few $1,000s instead of hundreds of thousands of dollars. And you could get a final finding of self-defense. And if it's a finding of self-defense at that pretrial hearing, everything stops. You are granted immunity from further prosecution, immunity from, in many states, civil suit as well. And that accelerated way of arriving, that pretrial way of arriving at a finding of self-defense, is what the self-defense immunity provision should be understood to be. Okay? So it's an accelerated way of getting to a finding of self-defense without having to go through a full-blown trial. That's the important part to understand here. And the officer here sought his self-defense immunity hearing. The arguments were made there. And the judge in that hearing, who would also be the trial judge if it went to trial, that judge granted immunity, saying, yes, there was grounds here for self-defense, and the officer fired rounds in self-defense. And if you fire rounds in reasonable self-defense, and of course, one of the elements of self-defense is reasonableness, it's a required element of self-defense. If you fire a round in reasonable self-defense and you injure a bystander, you're not held criminally liable for the injury to that bystander because your conduct was reasonable under the circumstances. It's a terrible thing that a bystander was injured. It's not a good outcome. But your justification for firing at whoever you would have been justified in hitting with the round carries over. That good intent is transferred over to the bystander who was injured, as long as you were acting in reasonable self-defense towards the person against whom you intended the force to occur. So the trial judge says, well, I find all of that to have been present here on the facts of this case, so I'm granting immunity. And the prosecution appealed that grant of immunity, because the grant of immunity stops everything for the prosecution. So I always say, often say, that if a prosecutor wants to take you to trial, you're going to trial. If he's got to present evidence to a grand jury, well, the grand jury is a rubber stamp for him. In many states, he doesn't even need a grand jury. He can just do what's called an information, a sworn document, and that's put in front of a judge instead of a grand jury indictment. But regardless, all of this is really a rubber stamp. If the prosecution wants to take you to trial and there's a scintilla of evidence to support their narrative of guilt, off the trial you go. Well, self-defense immunity changes that, because now you can have this pretrial hearing, and if you can convince the judge that it was lawful self-defense, he can grant you immunity, and that ends the criminal justice process right there. It's taken out. It's no longer the prosecutor's whim if you go to trial. If you're granted immunity, it's taken out of the prosecutor's hand. So it's a great thing from a lawful defender perspective. So the immunity was granted. The state appealed that up to the Court of Appeals in Kansas. They affirmed the grant of immunity, and then the state appealed that decision. And why can the state appeal these things? You might wonder. Because if you're acquitted at trial, the state can't appeal that. Right? Under double jeopardy, it's done. But this is not an actual acquittal by a jury. This is a grant of immunity by a judge. It's a legal finding by a judge. So the judge's legal findings are subject to appeal. So it was appealed to the Court of Appeals. The Court of Appeals affirmed the grant of immunity, and then the state appealed that decision up to the Kansas Supreme Court, and the Kansas Supreme Court rejected that grant of immunity in the decision we're going to go through in a moment. So that's kind of the factual and legal history background of how we got ourselves to where this decision is. At this point, before we dive into what a cowl looks like, I ought to mention that the sponsor of today's show is none other than Law Self-Defense itself. Let's see, do I have my little graphic here? I do. Let me pull up our sponsor graphic. Always nice to have. And here it is. Get the book that makes it easy to understand the 5 elements of self-defense law for free. This is the book, folks. It's a real physical book. It's not a PDF download. You can go to Amazon. In fact, I encourage you to go to Amazon, look up Law Self-Defense Principles. You'll find it there for $25 plus shipping and handling. You'll also find we have well over 1,000 reviews. It's a solid 5-star rated book. So if you want to get it from Amazon, more power to you, but it is $25 plus shipping and handling on Amazon. Or you can order it from us and will eat the cost of the book. We do still ask you to pay the shipping. Unless you want to come to our office in Castle Rock, Colorado, then I'll hand you a book. But if you want the convenience of the book being shipped to you, then we ask you to pay for that convenience. It's the shipping and handling. But the cost of the book we eat. So you can get this book. And by the way, those of you who may have already read this book, if you're in the chat, if you could put a number from 1 to 5, 1 being poor, 5 being 5-star rating, in the chat of your opinion of this book, assuming you've actually read it. I would appreciate it if you would do that to give some kind of social validation to what I'm saying about the quality of the book. If you'd like to get this book for free, you can get it at lawofselfdefense.com/free book. Easy enough to remember. We also have a hardcover copy of the book, which makes a great gift. It's a beautiful book. Same book, just in hardcover. We can't give these away for free. They're too costly to manufacture, but you can get the hardcover at lawofselfdefense.com/gethard. Get hard. There you go. And if you don't even want to pay shipping and handling, we have something that's 100% free. And that is our little Law of Self-Defense, 5 Elements of Self-Defense Law cheat sheet. It lists the 5 elements of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. Provides a brief description of each. This costs literally nothing. It's just a PDF download. So if you do nothing else today, I would urge you to at least download this, and you can get this at lawofselfdefense.com/elements for the 5 elements of self-defense cheat sheet. All right, folks. So let's dive into a little more detail about self-defense immunity, how it should be properly understood, how it actually works. And then we'll see how later in the actual Kansas Supreme Court decision, how badly they mangle these legal concepts. And I have a bunch of little, let's see, PowerPoint slides here. If I can find my first slide, here it is. All right, so as I already explained, let's see. The best way to understand self-defense immunity is as a accelerated, less expensive, less risky way of arriving at a finding of self-defense in a particular case where a defendant's been charged with the use of force crime. For our purposes, let's limit our consideration to murder or manslaughter, for example, and then they raise the legal defense of self-defense. Now, normally this is done at a trial. And at a trial, of course, for a killing case, murder or manslaughter, it's very common to burn through $200,000 in legal expenses before you get to trial. So these things are extremely expensive, and there's always a risk of getting convicted, even if you're innocent, at least a 10% risk of getting convicted for the most innocent defendant in the world if we put you in front of a jury. And then, folks, once you're convicted, during the trial itself, you're presumed innocent until proven guilty beyond a reasonable doubt. But once you're convicted, then all the legal presumptions are against you. So people often seem to think like, well, you can appeal a conviction, and that appeal is like a do-over of the trial. It could not be less true, folks. During the trial, all the legal presumptions are in your favor. If you get convicted anyway, well, once you're convicted, all the legal presumptions are against you. It's presumed now that you're guilty, as the jury decided. So you have that risk. If you argue self-defense at trial and you lose, you're basically done. Appeals are for losers, right? Technically, you lost a case, and also everything's against you now, moving into the appellate environment. All the legal presumptions are against you. And very, very few, less than 1% of appeals result in a win for the defendant, for the appellant on appeal. And the win defined in this context is not a determination that you're not guilty. It's simply that an error was made at trial that was sufficient to warrant a new trial. So you just get to go through the whole thing again. I mean, that's a win. It's better than still being convicted, but it's not like you're just set loose to walk free. So that's the cost and risk of making this self-defense argument at trial, which is the traditional way to do it. Self-defense immunity allows for a pre-trial hearing that's much less costly. So it's not free. It's probably still a few $1,000s, maybe a few tens of thousands of dollars, depending on how much of a mini trial you make it, but much, much less than the hundreds of thousands of dollars of a full-blown trial. And it's a much less risky affair, because the worst case in a self-defense immunity hearing is that the judge decides you're not worthy of immunity, and then you just proceed to trial. So it's not like if you lose the immunity hearing, you're convicted of the crime. If you lose the immunity hearing, well, you still have the process you had before, which was the trial itself. So there's no, well, I shouldn't say there's little procedural risk from going through the hearing, the self-defense immunity hearing. Some defense attorneys will tell you there's a strategic risk in that because the pretrial self-defense immunity hearing is a mini trial, you're making your defense legal arguments there pre-trial. So the prosecution gets to hear them, and you're attacking the prosecution's case pre-trial. So the prosecution gets to see your attacks and how effective they are, and the prosecution might change its own strategy for the trial itself, having learned what you're planning to do in the pretrial hearing. So that is a definite possible risk. But procedurally, there's no risk. If you lose the immunity hearing, you still have the option. In fact, you'll still go through the trial itself. So that's the benefit of a pretrial self-defense immunity hearing. And I'm a huge fan, folks, of self-defense immunity procedures. As far as I'm concerned, these are far more important in most good guy cases of self-defense than stand your ground laws, for example. And I'm a huge fan of stand your ground laws. Don't get me wrong. But the truth is, in most good guy cases of self-defense, stand your ground's not an applicable issue. Because most of us, if we had the option of safely retreating from a deadly force fight, we would do that before we got into a gunfight, for example. So generally, if we could have retreated, we would have retreated. So we would have satisfied a duty to retreat regardless. So in most good guy cases of self-defense, stand your ground as a legal doctrine is not relevant, not applicable. But self-defense immunity is applicable in every self-defense case, arguably, because it provides this accelerated, less expensive, less risky way of arguing and getting to a determination of self-defense without having to go through a full-blown trial. So that's the procedural aspects and reality of self-defense immunity. It's not some weird parallel way of arguing self-defense, by the way. Let's dive into that now. Because it's basically just arguing self-defense. You're just doing it in a pre-trial setting. So when you're arguing self-defense at trial, what are you really arguing? You're arguing the 5 elements of self-defense. Just like on this cheat sheet you can get at lawofselfdefense.com/elements. Those elements are innocence, imminence, proportionality, avoidance, and reasonableness. And once you've successfully raised this legal defense, which generally isn't hard to do for normally law-abiding people who've been involved in a use of force event and are claiming self-defense. But once you've effectively raised this legal defense of self-defense, so it's permitted to be argued at trial, then the state has the burden of disproving self-defense beyond a reasonable doubt. That's the legal argument that's happening in the courtroom. And to disprove your claim of self-defense, the state does not have to disprove the claim in its entirety. It has to disprove beyond a reasonable doubt any one of these required elements. Now, I say there's 5 elements. There's up to 5 elements. So sometimes not all 5 elements are required. Most states, for example, are stand your ground states. 39 states are stand your ground states. So they do not require the element of avoidance here in otherwise lawful cases of self-defense. There are ways to reacquire the element of avoidance if you screw things up defending yourself. But in otherwise lawful cases of self-defense, most states don't require the element of avoidance, in which case there's only 4 elements you need to worry about. But however many elements are in play, whichever the elements of the up to 5 elements are required based on the law and facts in your particular case, they're all required. They're each required. And if the state can disprove any single one of them beyond a reasonable doubt, it doesn't just diminish your justification of self-defense, it obliterates your justification of self-defense. And that's a problem because self-defense, raising the legal defense of self-defense, is inherently a defense of confession and avoidance. You're not denying it was you who fired the shot. You're conceding it was you who fired the shot that killed the guy, but you're seeking to avoid criminal liability on the grounds of justification. So if you lose the legal defense of justification of self-defense, all that's left is your essentially confession to being the guy who fired the fatal shot. That's pretty much a walkaway conviction for the prosecution. And of course, the prosecutor knows this. When he's dealing with a self-defense case, he knows you've basically conceded to the underlying conduct. That's the basis for the charge. But he has to disprove beyond a reasonable doubt this legal defense of self-defense that you raised. And he can do that by disproving beyond a reasonable doubt any one of the required elements: innocence, imminence, proportionality, avoidance, reasonableness. Again, up to 5 elements. Some elements may be legally waived for one reason or another, in which case they're not in play. But whichever elements are in play are targets of attack for the prosecution. He knows this. He's looking at that investigative report, witness statements, forensics evidence, all this stuff to see if he believes that there's at least one element of that claim of self-defense that's vulnerable to disproof beyond a reasonable doubt. If he sees that, it looks like an easy conviction, and off the trial you go. If he doesn't see that because you did things right, then you're hard to convict. And by the way, folks, don't forget, we do a couple times a week an absolutely free Hard to Convict webinar. It's a couple of hours long, doesn't cost a penny, but there are limited seats for each one, so you do have to sign up ahead of time. It's about 2 hours of teaching you a bunch of, exposing a bunch of self-defense law myths, things we've all heard on the internet that I'm sorry to say are not true, and explaining to you how you can make yourself hard to convict if you're compelled to defend yourself, your family, your property. And you can participate in that free webinar. Sign up for it. Doesn't cost a penny, but you do have to sign up at hardtoconvict.com. All right, so that's what you've done. When you raise the legal defense of self-defense, you're raising these 5 elements up to 5 elements and placing the burden on the state to disprove one of them beyond a reasonable doubt. That's if you're arguing self-defense at trial. That's the burden on the prosecution to disprove at least one of those required elements beyond a reasonable doubt. If the prosecution can do that, your justification of self-defense collapses and it's an easy conviction. Well, what do you have to do when you're arguing in the self-defense immunity hearing? Is this somehow a weird alternative way of arguing self-defense? And the answer is, it's not. It's exactly the same process. Exactly the same elements need to be raised. The same elements of innocence, imminence, proportionality, avoidance, and reasonableness, because you're arguing the same legal defense. At trial, you're arguing self-defense in front of a jury. In a self-defense immunity hearing, you're arguing self-defense in front of the judge at this pretrial hearing. But in both cases, you're arguing self-defense. All self-defense immunity hearings are doing are saying, if it looks to the judge like it was self-defense, he will grant you immunity. But the elements of self-defense at that pretrial hearing are the same as the elements of self-defense at the trial. It's the same self-defense legal defense. Now, there are variances in the standard of proof required. So at trial, the state has to disprove one or more elements beyond a reasonable doubt to overcome your legal defense and self-defense. Typically, at a pretrial immunity hearing, you have to prove each of the elements of self-defense by a preponderance, 51% of the evidence. So the burden may well be on you. That's generally the case with self-defense immunity, and to a higher standard. So you need to raise not just a reasonable doubt that it could have been each of the elements, but you have to show each of the elements, convince the judge you've shown each of the elements by 51% of the evidence. So that changes, but the elements itself are unchanged. So what you're arguing, the check boxes that have to be checked are the same in a pretrial self-defense immunity hearing and in a self-defense argument at trial. Same 5 elements, or whichever the 5 elements would be required under the law and jurisdiction of that particular state. So next slide. I have about 7 of these, I think. So what happens? You argue self-defense immunity at trial. So what the judge is asked to answer, the question in front of the judge, is, does your conduct, your use of force, qualify as self-defense under those 5 elements? If the answer is yes, then he grants you immunity and everything stops. That's the end of the criminal justice process for you. If he says, nope, I'm not convinced by a preponderance of the evidence, by a majority of the evidence that it was self-defense, then he denies you immunity. You're not convicted. It just means then you go off to trial. And at trial, you again argue self-defense, and frankly, in a more favorable setting, because now instead of you having to prove self-defense by 51%, now at trial, the state has to disprove self-defense beyond a reasonable doubt. And the jury now is being asked to determine whether or not your conduct qualifies as self-defense. And if they say, yes, it does, well, then you're acquitted. And that ends the process. If they say, no, it doesn't, well, then you're convicted. Because remember, you've conceded to the underlying conduct. That's the basis of the criminal charge in a self-defense, confession, and avoidance legal defense. But again, the arguments being made in both the immunity hearing and the trial are the same. It's the same 5 elements of self-defense. The only difference is in the pretrial immunity hearing, if you lose, it just means you go off to the next step, the trial, which you would have done anyway. That's it. All right. So, but it's not some weird alternative way of arguing self-defense, the immunity hearing. It's still the same self-defense argument. Now, what if your conduct is claimed, your conduct in self-defense is claimed to have been reckless? So that's different than intentional. Recklessness is a mens rea, a state of mind that carries criminal liability and is different than intent. In this particular case, the officer shot at the dog that was arguably rushing at him and unintentionally hit the girl. That's what the state is calling reckless endangerment of the girl. He didn't intend to hit the girl. The state's arguing he may not have intended it, but his conduct was reckless. What is recklessness? Recklessness is creating an unjustified risk of deadly force harm to another and ignoring that risk and engaging in the conduct that creates that risk regardless. So it's not negligence. It's not, which would only be the basis for civil liability. Negligence is the argument that, well, maybe you didn't know you were creating a risk, but you should have known. With recklessness, it's not that you should have known you were creating a risk. It's that you did know. You did know. It's undeniable that you knew you were creating a risk and you ignored that risk and did it anyway. Negligence is a lower state of mental culpability, gives rise only at worst to civil liability. Recklessness gives rise to criminal liability. And by the way, when you're basically, if you're handling a gun in what would otherwise be a negligent way, it's automatically recklessness because guns are inherently dangerous instruments. You're held to a higher standard of care. So here, of course, the officer was discharging a gun and the state's arguing it was reckless. What does recklessness do to a claim of self-defense? Well, it obliterates it because one of the elements of self-defense is reasonableness. That your conduct was that of a reasonable and prudent person. Recklessness is the absence, by definition, of reasonableness. Remember, recklessness is creating an unjustified risk of death. That can never be reasonable. So your conduct was either reasonable, and that would satisfy that element for purposes of self-defense, or it was reckless. And if it was reckless, it cannot have been self-defense. Because recklessness obliterates that element of reasonableness, and without reasonableness, you can't have self-defense as a legal defense. Now, whether it was reasonable or whether it was reckless would typically be a finding of fact made by a jury at the trial or by a judge in a pretrial self-defense immunity hearing who's playing the role of finder of fact in that hearing. But some finder of fact would make the determination, all right, we believe it was reasonable, in which case it could have been self-defense if the other elements are also satisfied, or we believe it was reckless. And if it was reckless, by definition, it cannot have been self-defense. Well, if that's what recklessness does to self-defense as it would be argued at trial, what do you think recklessness does to self-defense in the immunity hearing? Well, folks, it does exactly the same thing. It obliterates that element of reasonableness and therefore obliterates self-defense. Because again, the fundamental argument is the same in the immunity hearing and in the trial. It's those 5 elements of self-defense. And if your conduct in claimed self-defense was reckless, then by definition, it was not reasonable. And if it wasn't reasonable, it cannot have been self-defense. And if it cannot have been self-defense, you cannot qualify for immunity. So all you need to know about the immunity hearing in this context is the judge running the immunity hearing was essentially asked to determine whether or not he believed the officer's conduct was reasonable or reckless. If it was reasonable and the other elements were also satisfied, then it would be self-defense immunity granted. If it was reckless, then reasonableness is obliterated. There is no self-defense. and immunity would not be granted. And this rationale, this reasoning also applies to the bystander issue, which this court decision tends to conflate what I just explained, this analysis about how recklessness destroys the framework of reasonableness. It tends to conflate that with bystander. But really the bystander issue, the fact that it was a bystander here injured, doesn't really change anything. Because if it was reasonable self-defense, the fact that a bystander got injured is legally acceptable. The bystander getting injured becomes legally unacceptable if the use of force in purported self-defense was unreasonable, was reckless. So if it was lawful self-defense, reasonable, non-reckless self-defense, injury of the bystander is just an unfortunate event without criminal liability. If it was reckless use of force, well, then it doesn't qualify as self-defense. And the injury to the bystander is also reckless. And that, of course, would give rise to felony reckless endangerment as a criminal charge and a conviction, potentially. All right, so with that framework designed, let's turn now to the actual court decision. And by the way, folks, I'm happy to answer questions about all this. If you're watching this on the Law of Self-Defense member dashboard, let's see if anybody is there. Yeah, they are. Okay. Law of Self-Defense members will get their questions prioritized for answering. And of course, they don't have to, there's no cost to them for that. They're already Law of Self-Defense members. For those of you watching this on YouTube, if you have questions you'd like answered, you need to put them in super chat form. That's the only way they'll get answered. Preferably at least $5, folks. Otherwise, I just can't get to it. All right, so let's take a look now at this actual court decision by the Kansas Supreme Court. And by the way, if you'd like to look it up yourself, you can do that at, so this decision is State v. Betts. The state, of course, is Kansas. Kansas v. Betts. It's spelled B-E-T-T-S, 2 T's. And it was released when? July 29th. So just, I guess, last Friday. If you'd like to read the decision yourself, you can find it at lawofselfdefense.com/Betts, B-E-T-T-S. That's where I'm reading it off of right now. In fact, I'll pull it up on the screen and we can start working through this decision and see how the Kansas Supreme Court fails to follow the rather simple legal reasoning framework that I just put in front of all of you in explaining what a cow looks like. So let me compress this up so it's a little more legible. It's still a little small, isn't it? Let me see. Whoops. Okay, that's a little better. So State v. Betts, you can find this decision at lawofselfdefense.com/Betts. All right, so here we have a syllabus, kind of a summary by the court. The Kansas State's annotated 215231 is their self-defense immunity statute, and the syllabus reads that the self-defense immunity statute allows a criminal defendant in certain cases to claim self-defense immunity from prosecution for the justified use of deadly force. This statutory immunity is confined to circumstances when the use of such force is against a person or thing reasonably believed to be an aggressor. The statute does not extend immunity for reckless acts resulting in unintended injury to bystanders while the defendant engaged in self-defense with their perceived aggressor. So right away, we have a misstatement of the law, even just in the syllabus. This first sentence here is correct. Immunity is confined to circumstances where the use of force is against a person or thing reasonably believed to be an aggressor. That's true. But if that use of force qualifies for immunity, that means it qualifies as self-defense. And if it qualifies for self-defense, that qualification would also apply. It means the use of force was reasonable. And if the use of force was reasonable self-defense, that also qualifies injury to a bystander. So if the use of force against the intended person was reasonable self-defense, and it has to be reasonable to be self-defense, then injury to a bystander, unintended injury, would also be covered. That's why this next sentence is wrong. It says the self-defense immunity statute does not apply when there's injury to an innocent bystander. That is incorrect. Now, it would not apply, immunity would not apply to injury to a bystander if the injury to the bystander was reckless. But that's because then the use of force was not lawful self-defense, because reckless use of force can never be lawful self-defense. But the issue here is not that a bystander was injured. That's not the relevant point. The key issue here is, was that use of force reckless or reasonable? If it was reasonable use of force in self-defense, it qualifies for self-defense immunity with respect to the intended target of the force and with respect to bystanders, both. And if the use of force was found to be reckless, then it doesn't qualify as lawful self-defense, either with respect to the intended target or to the bystander. But the variable here is not the intended target / the bystander. The relevant point, the key issue is, was the conduct reasonable or was it reckless? Not the bystander issue, which is what the court gets wrong here. And by the way, one of the reasons the court gets this wrong, I expect, is that there's a cliche in the law that hard cases make for bad law. And here we have a tough case. We have a young innocent girl who is unintentionally injured by this officer's fire. And naturally, you feel sympathetic towards the girl over this. But if it was, an arguable co-conspirator of the bad guy, that they were, the domestic violence aggressor, would anybody care as much about any of this? Probably not. But the fact that the unintended bystander victim was a young girl makes for an emotional appeal in media reporting for sure, that helps drive the kind of the political energy behind this type of case. So then the court gets into its actual opinion. Biles is the judge. By the way, when you see J here in the judges' names, that means judge. They don't all have the initial J. So Biles provides a factual summary. I've already shared this. The police were responding to a domestic violence situation. Officer Betts fired 2 gunshots at a fast approaching dog, the pit bull he thought was attacking him. He missed, and bullet fragments struck a young girl sitting nearby. The state charged the officer with reckless aggravated battery for injuring her. Betts moved to dismiss the charge before trial. So the state, this decision does a very poor job of explaining all this. But what's meant here is Officer Betts demanded, as is his right, a pretrial self-defense immunity hearing. He argued that state law immunizes his use of deadly force in self-defense, even if he acted recklessly and regardless of who got hurt. Here, the cop is wrong. He's half wrong and half right. He's entitled to immunity regardless of who got hurt if his use of force was reasonable self-defense. But he's not entitled to immunity or self-defense if his use of force was reckless. Recklessness means not reasonable. If it was not reasonable, it can't be self-defense. If it can't be self-defense, you can't get self-defense immunity, right? That immunity is premised on self-defense. So here the cop made an incorrect legal argument. Now, of course, maybe his lawyer knew they were making an incorrect legal argument. They were just hoping it would work. And it did work, because the officer was granted immunity at the pretrial immunity hearing. The district court, meaning the trial court, agreed and dismissed the case. The state appealed. The Court of Appeals affirmed the grant of immunity, and the state appealed that up to the state Supreme Court, which is where this decision comes from. And they write, on review, we reverse the grant of statutory immunity and remand the case to the district court for further proceedings. So they're right to reverse the grant of immunity, because there is a fact in dispute, and that is whether or not the conduct was reckless. The use of force was reckless. Again, if it was reckless, it can't have been self-defense. If it can't have been self-defense, then it would be, it can't be a grant, the basis for a grant of self-defense immunity. Now, could the pretrial hearing court, the trial court, have said, yeah, we just don't think this is reckless. I, the judge in this pretrial hearing, acting as the finder of fact in that self-defense immunity hearing, I don't believe this was reckless. And I'm granting immunity. Well, findings of fact are not really appealable. The trouble here is that the immunity was granted on the basis that it could be correctly granted even if the officer's conduct was reckless. That's not correct. So a finding of recklessness or not recklessness has to be made before you can know whether or not it was self-defense, before you can know whether or not immunity is appropriately granted or denied. Again, that's the key legal issue here. Was the use of force reasonable or was it reckless? And by the way, folks, I don't have a dog in this fight. Ha ha ha. This is involved a pit bull attack, apparently. But I don't know whether or not the use of force was reckless or not. That's a finding of fact decision. That would be made by the jury or by the judge in the pretrial hearing. And I can see arguments on both sides. A pit bull is charging you, a dog large enough and strong enough, presumably, to cause serious bodily injury. Generally, you would be privileged to use force to defend yourself against that attack. Does it become reckless when there's a young girl in the line of fire? Arguably so, because are you creating now an unjustified risk of harm to that young girl? As we'll see later, there's this decision quotes a dissent out of Pennsylvania arguing that, hey, would we allow someone to detonate a grenade in a crowded shopping mall in an act of defense against an attack, knowing the grenade was going to kill innocent people, innocent bystanders? Probably not. Might there have been alternatives to dealing with this dog other than firing the shots? OC spray, taser, knife, things that would not have endangered the girl? Again, these are all matters that would be factually argued in front of a finder of fact, in front of a jury or the judge in the pretrial hearing. And whatever they determined, whatever facts they found to be credible would be what everyone had to live with, because findings of fact are not really appealable. But the finding of facts does need to happen so that we know whether or not the use of force was reckless or not. It's not a magical answer that's handed down from the heavens. It's an answer that comes from the finder of fact. But there's no way to know whether this was a reasonable use of force in self-defense until you make that finding of fact, that determination of recklessness or not. So let's continue here. This appeal presents facts we have not considered before. So this is another weird thing about this decision. This specific set of facts has not before appeared it's not described in the statute, the self-defense immunity statute, or the self-defense statute in any real way. And there's not existing case law that has a similar fact pattern. So this Kansas Supreme Court is basically saying, well, we don't know what to do with this. Well, that's not correct. The Kansas Supreme Court says, well, we're not supposed to make our own laws and we're not supposed to make public policy. And that's absolutely true. The courts are not supposed to do that. But there's more than statute and case law in legal reasoning. There's well-established legal doctrines and principles, many of which I described for you when I was sharing those PowerPoint slides with you. Things like transferred intent when an innocent bystander is hit. Those fact patterns happen all the time. And they would be equally applicable in a self-defense immunity hearing as they would be in arguing self-defense at trial. And they have been argued in self-defense at trial thousands of times. But this Kansas Supreme Court decision seems to think that arguing self-defense in the immunity hearing is somehow fundamentally different than arguing in a trial. It is not. It's the same legal argument, the same elements. So to the extent we know how to deal with an injured bystander, if we were arguing self-defense at trial, we would deal with that in exactly the same way in arguing self-defense in an immunity hearing. But in any case, the decision says this appeal presents facts we've not considered before. In the typical self-defense immunity case, the state charges a defendant with an intentional crime committed against a person claimed to be the aggressor. And when the defendant invokes statutory immunity from prosecution in a case involving the use of deadly force against that alleged aggressor, so someone's attacked you, you've shot them, maybe killed them, there's a criminal charge based on that use of force. Now you're asking for self-defense immunity. We determine, they mean the trial court, determines whether the defendant had a reasonable belief such force was necessary to prevent imminent death or great bodily harm to the defendant himself or some third person, whether it was self-defense or defense of others. So far, that's quite correct. It continues. But what about a circumstance like this, when the crime charged involves an innocent bystander who was unintentionally injured during the defendant's allegedly reckless conduct while engaging in self-defense? Here, the Kansas decision is conflating two different legal issues, the issue of the bystander and the issue of recklessness. And it's attempting to address these two variables simultaneously, and you can't. The issue of the bystander is simply addressed within the normal legal construct of self-defense. If it was lawful self-defense, the injury to the bystander is unfortunate but not criminal. If the use of force against the intended target was not criminal because it was lawful self-defense. On the other hand, if the use of force was reckless, then it's not lawful towards the intended victim nor towards the innocent bystander. So the legal issue here, again, is not the intended target versus the bystander. Either the use of force was lawful to both or unlawful to both. And you know it was lawful to both or not lawful whether or not it was reckless. So this is just sloppy legal reasoning by the Kansas Supreme Court. Then they find out, they do a spoiler with their decision. We hold that the Kansas self-defense immunity provision does not extend immunity to a defendant's reckless acts, and it shouldn't. If the act was reckless, it could not have been self-defense. So definitely, if it was reckless, self-defense doesn't apply, and therefore self-defense immunity wouldn't apply. So this first half of the sentence is correct. We hold that self-defense immunity does not extend to a defendant's reckless acts while engaged in self-defense. And then they conflate this so far correct statement with this irrelevant second variable of the bystander. That results in unintended injury to an innocent bystander. Again, it doesn't matter who was injured, the intended target or the bystander. All that matters is whether or not the use of force was qualified as lawful self-defense, non-reckless, or whether it was reckless and therefore not lawful self-defense. So they have a lengthy recitation of the facts, but I've already gone over the facts a couple times. The state charged Betts with reckless aggravated battery. And by the way, one of the concerns here could be, hey, if recklessness removes the conduct from the protection of self-defense, what would keep the state from just always charging people with recklessness? Right? Because if you're reckless, then self-defense is not a legal defense to reckless conduct. And that's true. So might a savvy prosecutor decide, hey, this guy's got a pretty good self-defense claim on the merits, but let's try to get around it by adding a charge of recklessness? Yes. In fact, that's exactly what they did to Rittenhouse. The Kyle Rittenhouse case, every person he actually shot, he clearly intended to shoot. Right? Even the guy, jump kick man, he missed, but he intentionally tried to shoot that guy. And for every one of those instances, he was clearly defending against an imminent deadly force attack in the moment. So the state knew, Prosecutor Binger knew that Rittenhouse had a pretty sound legal defense for each one of those events. So they added a recklessness charge, and that was reckless conduct towards the media reporter. So shots went by the media reporter when Rittenhouse engaged the first guy who tried to tackle him and fight him for his knife. Fight him for his rifle. The very first person shot and killed by Rittenhouse. A couple of those rounds went past the media reporter, and the state charged Rittenhouse with recklessness with respect to the media reporter. The idea being that even if Rittenhouse were to win on all the actual self-defense claims, we can still convict him on recklessness because the judge will instruct the jury that self-defense is not a legal defense to recklessness. With respect to the recklessness charge, the jury's not considering the elements of self-defense. They're simply considering, was that an unreasonable, unjustified use of force in the moment that created that risk to the media reporter? Now, ultimately, of course, Rittenhouse was acquitted of that charge as well. The jury decided, well, that may have been an unfortunate risk to the media reporter, but it was not an unjustified risk because it occurred in the context of Rittenhouse defending himself against the first guy. But the jury was, as the prosecutor knew they would be, as the defense knew they would be, the jury was instructed that although self-defense is a legal defense to all these other criminal charges, it's not a legal defense to this charge based on recklessness. So yes, a prosecutor can attempt to bring a charge of recklessness against you in an effort to get around your legal defense of self-defense, because self-defense is not a legal defense to a criminal charge based on recklessness. The challenge for the prosecutor there is there has to be some factual evidence to support a charge of recklessness. And frankly, the fact that this cop missed the dog is that factual evidence. He fired at the dog and he missed. Does that suggest, would that be consistent with a not non-reckless firing of his gun, a panicked, quote unquote, negligent firing of his gun, not using the sights, not firing the gun, not operating the gun the way you want an officer or anybody to operate their gun, right? If you're going to be firing rounds at something trying to kill you, do your damn best to operate the gun effectively so the rounds are hitting the target. Don't just send rounds down in the general area, right? That's what we would expect. And of course, we saw that, by the way, with the Indiana Mall, the Good Samaritan killer of the active shooter in the Indiana Mall, Elijah Dickens. The fact that he got, what was it, 10 hits, 8 hits? I forget now. 8 out of 10 hits, I believe it was, starting at 40 yards out with a handgun. The fact that he got 8 out of 10 hits, that supports an inference that he was not negligent in firing those rounds because he was getting his hits. If he'd fired 10 rounds and hit once and sent 9 rounds randomly around the mall, you think that might have allowed for an inference of negligent firing of the gun? Yeah, it could have. So here, the fact that the officer fired 2 rounds and missed both times, and by the way, I'm completely sympathetic. So dogs rushing at you are very difficult targets to hit. They're small, they're fast moving. I've been through, and someone misunderstood me the other day. I've never shot a dog, folks, but I've been through training exercises where they simulate a dog attack and you have to engage that target. And it's very, very difficult to do in my training experience, not real world experience shooting a dog. Hard to do. So I'm sympathetic to the officer, but the fact that he fired twice and missed both times, it's not exactly consistent with non-reckless firing of the gun. So that's the issue. He's been fired with reckless battery because so battery is when you cause an unlawful contact with someone, either with your hand or some projectile under your control, in this case, bullet fragments. Assault would be putting someone in fear of that unlawful contact. Battery is when you actually make the unlawful contact. If you do both, that's the classic assault and battery. Here he's charged with felony reckless battery. So he never intended to cause injury to the girl. Otherwise, it would be simply felony battery. It's felony reckless battery because the battery was unintentional, but done under circumstances where it was reckless, where any reasonable person would have known he was creating an unjustified risk of death or serious bodily injury, and he did it anyway. So he ignored a known risk. That's what elevates recklessness above negligence. Negligence being merely civil liability, recklessness allowing for criminal liability. So Betts, the officer, filed a pretrial motion to dismiss seeking self-defense immunity. This is that pretrial self-defense immunity hearing. It provides a person who uses force, which is justified pursuant to Kansas self-defense law. That's what the statute is, 21-5222. A person who uses force, which is justified under Kansas self-defense law, is immune from criminal prosecution and civil action for the use of such force. In other words, if the use of force was lawful self-defense, as defined by the self-defense statute, which would define within the scope of these elements, folks, the elements of self-defense, if the use of force would qualify, check the boxes of the elements of self-defense, then it's lawful self-defense for both self-defense at trial purposes and for immunity purposes. It's the same test. So if it was lawful self-defense, then have a privilege of immunity from ongoing prosecution. So that's what I've already described as generally being the case with self-defense immunity statutes. Then the court looks at the self-defense immunity statute itself, which is very typically structured. We have a first paragraph here that talks about the use of essentially non-deadly force in self-defense. It lists the various conditions that have to be met. And then we have the second paragraph, B, which covers deadly force in self-defense. And it in essence, adopts the additional condition that before you're justified in using deadly force in self-defense, you must have been facing a deadly force threat. Otherwise, it's the same elements, the same 5 elements each time, with the exception of the element of avoidance, of course, because Kansas is a stand your ground state. So in his motion for immunity, Betts argued that as long as his use of deadly force against the dog was justified, as long as it was qualifies, hits the check boxes for self-defense, any unintended harm to an innocent bystander should not change his entitlement to immunity. In other words, if his use of force checks the boxes for self-defense, that privilege to use that force transfers over to any unintended bystander who might be hurt. That's true. If the use of force was lawful, meaning it was reasonable, because reasonableness is one of the conditions of lawful self-defense. If it was reasonable self-defense with respect to the intended target, it's also legally justified with respect to any innocent bystanders who are unintentionally hit. That's a correct statement of the law. So if it would have been self-defense, meeting the conditions of self-defense, then it should also trigger the grant of immunity, even though an innocent bystander was hit. The state responds with 3 arguments. Now, I think the state is correct in all 3 of these arguments, by the way. But the Kansas Supreme Court justifies their reversal here on a different grounds than what the state argued. So the state argues, first, self-defense immunity is never available to those who act recklessly. Absolutely correct. Because if you act recklessly, by definition, you are acting unreasonably. And if you act unreasonably, you're missing the element of reasonableness required for self-defense at all. And if you're not qualified for self-defense at all, you're certainly not qualified for immunity premised on the self-defense you don't qualify for. So absolutely, number 1, self-defense immunity is never available to those who act recklessly. 100% correct. Number 2, state argument. A reasonable person in Betts' circumstances would not believe firing a handgun in the living room was justified because he saw the children and knew a dog was on the premises before he arrived. I'm actually not sure what the actual argument is here by the state. And this may not be a correct paraphrase of their argument. A rational argument would be that a reasonable person in Betts' circumstances would have known he was creating an unjustified risk to the girl by shooting at the dog under those circumstances. And then third, self-defense immunity is reserved for deadly force applied against a person, but not against an animal. So this is a little more of a subtle argument. I would argue here that the state is actually correct, that the legal defense raised here may more appropriately be not self-defense. Because if you look at the actual self-defense statute, what it contemplates is use of force against a person. And here we have use of force against an animal. And it's not the same justification. Normally, if you can't just walk down the street and shoot a dog, right? That would by itself be unlawful, presumptively unlawful, unless you had a good reason. And that's what's called the legal defense of necessity, the doctrine of necessity, or the doctrine of lesser harms. And the doctrine of necessity or lesser harms or lesser evils, different states call it different things, but the legal concept is the same. And that is, it's permissible for you to commit some small harm to avoid a greater harm. It's a balancing test. So normally, for example, smashing out a car window with a rock, that's criminal mischief against property, right? That's a crime. You can't just walk down the street and smash out someone's car window with a rock. But what if you did it because it's a 100-degree day and you saw a baby locked in its, belted in its car seat with the windows closed in the car and all the doors are locked. And you have good reason to believe that baby's going to die in that car if it's left there. So you break the window so you can unlock the door, get the baby out of the car so it doesn't die. Are you committing a small wrong by breaking the window? Sure. Are you doing it to avoid a much greater harm, the death of the baby? Yes. So under the doctrine of necessity or the doctrine of lesser harms, it's forgivable. It's excusable in the legal terminology. It's excusable for you to commit the small harm to avoid a greater harm. That would seem to me to be the appropriate legal defense here, not so much self-defense, but doctrine of necessity defense. And arguably, I mean, I presume the reason that the defense did not do that was because self-defense immunity does not apply to the doctrine of necessity. So it doesn't say you get a grant of immunity if your use of force qualifies under the doctrine of necessity. It says you get a grant of immunity if your use of force qualifies as self-defense. And so the defense team is saying, well, if we want to go for this immunity thing, we can't be raising the legal defense of necessity, which I would argue is more appropriate when you're shooting a dog attacking you than shooting a person attacking you. If we want to go for immunity, we necessarily have to argue the self-defense legal defense, which applies to defense against people. I think technically speaking, that's the wrong defense here. I think defense of necessity is the right defense, but he'd be compelled to argue that at trial. I don't know. Can you folks hear the local train going by? That's the one downside I'm learning about this new office here is the train tracks are just a block away. And we have train crossings in town that don't have guard gates. So the train is obliged to blow its whistle. Not sure if that comes over the microphone or not. I can definitely hear it in my earbuds though. All right. So I think that's also a completely reasonable argument by the state. But again, that's not the basis on which the Kansas Supreme Court here arrives at their decision. So 3 witnesses for the state testified at an evidentiary hearing on the motion to dismiss. This evidentiary hearing is the pre-trial self-defense immunity hearing we're talking about. One officer described the incident. Another was a crime scene investigator, so she came afterwards. She explained how the bullets fragmented. And then a police lieutenant, a former range master in charge of the department's firearms training, described the policy and use of deadly force in defense of animals. And he says, well, you're allowed to use a gun in defense of yourself against an animal attack. We shoot dogs with some regularity. He would testify. We do shoot dogs pretty regularly. But again, the fact that it's allowed under policy doesn't mean that doesn't relieve you necessarily of criminal liability. Policy is policy. You violate policy, you may lose your job. It doesn't mean you did something criminally wrong. And if you're within policy, that doesn't mean that you're free of criminal liability if you're otherwise guilty under a criminal statute. Department policy cannot relieve you of criminal liability automatically. It may play a role in assessing whether or not what you did was reasonable. That's the policy. Reasonable officers follow policy. It may allow the jury to draw an inference that because your conduct was consistent with policy, it was reasonable and therefore justifiable. But you can all imagine a policy that would clearly be in violation of the law, and following that policy does not relieve you of liability, criminal liability under those circumstances. So following this self-defense immunity hearing, all the testimony of the district court limited itself to the state's arguments, rejecting each. I think that's a mistake. I think the state had good arguments. Self-defense immunity should be reserved to self-defense statutes. It says so explicitly. And self-defense statutes should be limited to use of force against a person. So I think the trial court made a mistake. They should have denied immunity on that basis. The judge in the hearing is the finder of fact. He's playing the role of the jury. He could have said, well, I find this conduct to have been reckless. He's free to do that as the finder of fact. That's not a legal finding. That's a fact finding. It's not subject to appeal, really. And if he had determined factually that it's a finding that it was reckless, then it doesn't qualify for self-defense or self-defense immunity. That would be another way the trial judge could have gone. The fact that he granted immunity tells us that he concluded the conduct was not reckless, or he should have had to conclude that. We don't really know the trial judge's thinking, the immunity hearing judge's thinking here, unfortunately. But the court said a defendant can assert self-defense immunity when charged with a reckless crime. This is wrong. This is bad law. You should only get immunity if it can be found that your use of force would have qualified as lawful self-defense. And it cannot qualify as lawful self-defense if it was reckless. So immunity cannot apply to a reckless use of force, period. Now, you may look at the facts and decide the use of force was not reckless, and then it may qualify for immunity. But you have to make that determination. If you find it was reckless, then it cannot have been self-defense, and it cannot be the basis for self-defense immunity. So that was mistaken. Second, the court addressed the state's argument that a reasonable person in Brett's circumstances would not believe firing a handgun in the living room with children nearby was justifiable self-defense. And again, the hearing judge's reasoning is difficult to understand here. The dispute in this case, the judge says, is whether Officer Betts should have fired his weapon in defense of himself under the circumstances, not whether he was or was not justified in defending himself. Well, no, those arguments are really the same argument. If he was not justified in defending himself, he should not have fired his gun. I mean, one follows from the other. Then the hearing judge says, well, arguably, if the shots had met their mark, Officer Betts would not have been charged with a crime. Meaning, if his shots had met the mark, he would not have been charged with reckless conduct. Well, maybe the fact that he missed both times suggests his shooting was reckless. In other words, even if it would have been otherwise justified, it becomes unjustified because he's doing it in a reckless way. If he's doing it in a reckless way, it's not reasonable. If it's not reasonable, it can't be justified as self-defense, as I've already said a ton of times. The court first concludes that Officer Betts was lawfully present in the home and had no duty to retreat. That's not really relevant to this legal analysis. Kansas is a stand your ground state, but that was not an issue in dispute. Neither party disputes that Betts reasonably believed that the use of force was necessary to defend himself from the dog's attack. Okay, fair enough, but that could be necessary under the doctrine of necessity, legal defense, not the necessity of self-defense. Those are two different legal defenses, and only one of them allows for immunity to be granted, and that's self-defense. The court finds that a reasonable person would have believed that the use of force in self-defense was necessary under the circumstances. Here, it sounds like the trial court is using self-defense in a non-technical way. In other words, to defend himself, as opposed to in the technical way of the legal defense of self-defense with those 5 elements. If you're defending yourself against a dog attack under the doctrine of necessity, you're also defending yourself. But the legal defense is not self-defense. The legal defense is the doctrine of necessity. The hearing judge concludes the injuries to the little girl as a result of the actions of Officer Betts were certainly unfortunate and regrettable. However, the court fails that it failed to meet its burden to demonstrate that the defendant's use of force was not justified. Again, lots of defects in legal reasoning here. And then finally, the court repeated its earlier rejection of the state's human versus animal distinction. I think the human versus animal distinction is legitimate. So I think the trial court made an error here in arguing that it's not a reason not to grant immunity. I think it is a reason not to grant immunity. I think immunity should be granted if the conduct falls within the boundaries of the legal defense of self-defense, but not if it doesn't. And the doctrine of necessity, which would be the normal legal defense to raise against an animal attack, not self-defense, which is specific to people, does not trigger. The doctrine of necessity does not trigger immunity. A court of appeals, so the trial court granted immunity, which in essence results in the discharge of the dismissal of the charges against the officer. Now, but that is a legal finding by a judge. It's not an acquittal, so the state's free to appeal that grant of immunity, and it did. It appealed to the Court of Appeals. By the way, if you lose, here's an interesting quirk for you. If you go to an immunity hearing and you lose the immunity hearing, you don't get to appeal that finding. If the state loses and you're granted immunity, the state gets to appeal the grant of immunity. So you can't appeal the denial of immunity, but the state can appeal the grant of immunity. Why is that? Because generally speaking, you can only appeal once there's been a finding that would be final in the case. And if immunity is granted, that's a final finding in the case. There is no further criminal proceedings if you've been granted immunity. So because it's otherwise a final finding, the state's allowed to appeal that. If you're denied immunity, the process hasn't ended. The process just continues on to the trial. And the law says, well, you can still argue self-defense, but you have to do it at trial. You're not entitled to appeal the denial of immunity. Seems kind of unbalanced there, but that's the way the law works. So it was appealed to, the state appealed to the Court of Appeals. They affirmed the grant of immunity, and then the state appealed to the state Supreme Court, which is where we are now. And the state Supreme Court just reaffirms that they routinely grant review of statutory immunity under that statute. That's fine. Here, to argue its point, the state focuses on the mens rea for the charged offense. The mens rea is the mental state. The mental state here is recklessness. That's what the officer has been charged with, recklessness. And the state is correct to focus on that for reasons I've said already a dozen times. If the conduct was reckless, it's by definition unreasonable. If it's unreasonable, it cannot have been self-defense. If it cannot have been self-defense, it cannot be the basis for self-defense immunity. The state's making the right argument. But the Kansas Supreme Court doesn't like that argument. So the Kansas Supreme Court says the state focuses on the recklessness, but in our view, it's more meaningful that the crime charged here alleges unintended injury to an innocent bystander. No. The state Supreme Court, the Kansas Supreme Court, is wrong here. The key issue is the recklessness. It's not the innocent bystander. If the use of force was non-reckless, reasonable, lawful self-defense as towards the intended target, then it's lawful as with respect to any innocent bystanders. If it was reckless, not reasonable, not lawful self-defense with respect to the intended target, then it's not reasonable and not lawful with respect to the innocent bystander. What controls is not the intended target versus the innocent bystander. What controls is reasonable or reckless, one or the other. In any case, they continue to explain this. We start with the state's argument that self-defense immunity cannot prevent prosecution for reckless crimes because self-defense is available only in cases alleging intentional crimes. This is the correct statement of the law by the state. And the Kansas Supreme Court goes through a lot of word salad to try to explain why they feel that's not the case. And they're simply wrong as a matter of basic legal doctrine. In any case, again, I don't even know why the Supreme Court is now talking about recklessness again when they already said recklessness to them doesn't matter. They're wrong to believe that. But if you believe recklessness doesn't matter, that the whole issue is the bystander, then what are you still talking about recklessness for? So they spend a lot of time talking about why they think recklessness is not the relevant legal issue here. They're wrong about all of that. And then they talk about the bystander being injured. So what if the state alleges a reckless crime involving injury to a bystander? Only 2 Court of Appeals decisions have minimally touched on a similar fact pattern, but neither help. Here, the Kansas Supreme Court is saying, well, we don't have existing case law that answers this question, so we're at a loss on how to answer the question. No, we have well-established legal principles that apply here. It's definitely possible to get to a reasoned legal conclusion, and it ought to be based on the question of recklessness. So I agree with the Kansas Supreme Court that the immunity should be reversed, and this should go back to the trial court. But what the trial court should do is have another pretrial immunity hearing and make a factual finding on the question of recklessness, and or make a legal finding on whether or not self-defense applies to shooting at a dog, the legal defense of self-defense, or whether the proper legal defense there ought to be only the balancing of interest defense, the lesser harms defense, the defense of necessity. Because the trial court could say, one, this was reckless conduct. I'm deciding as the finder of fact, and therefore, because it was reckless, it was not self-defense, and because it was not self-defense, it can't be the basis for a grant of immunity. That would be one reason to deny immunity. Or they could say, we find the use of force under these circumstances was reasonable and therefore self-defense, and therefore the basis for a grant of immunity. But then they're making an explicit finding of fact on the question of recklessness. Or the pretrial hearing court could say, well, if they want to deny immunity, they could say, well, we think self-defense is not the appropriate legal defense here because you shot at a dog, not at a human. The intended target of the use of force was not a human being. Therefore, self-defense as a legal defense does not apply. The appropriate defense is the defense of necessity. We'll allow you to argue that at trial, but the defense of necessity is not grounds for a grant of self-defense immunity because the self-defense immunity statute specifically requires as a condition that you satisfy the self-defense statute, not the doctrine of necessity statute. So there we go. The state claims a reckless crime occurred when Betts fired his handgun twice at the dog while the girl sat nearby. Yep, that would be the grounds for a claim of recklessness. Now, the state doesn't get to decide whether it was reckless. That decision is a finding of fact made by the jury at trial or by the judge in the pretrial immunity hearing. Then the self-defense immunity statute talks about when you're privileged to use force against another person in self-defense. That's the 5 elements of self-defense. So when a defendant asserts self-defense immunity in a case involving reckless injury to an innocent bystander who the defendant did not perceive to be an attacker, immunity does not apply. That's correct. But again, the Kansas Supreme Court is conflating 2 distinct issues here. They're conflating recklessness and innocent bystander. The reason immunity does not apply has nothing to do with the bystander issue. It has to do with the recklessness issue. If it's reckless, it can't be self-defense. If it can't be self-defense, can't be self-defense immunity. If it's non-reckless, it can be self-defense. And if it can be self-defense, it would be self-defense. It would be justified with respect to the intended target or a bystander. And immunity would apply to either situation. This results, said more plainly, the reckless use of force against innocent bystanders lies outside immunity's stated scope. Yes, but not because of the bystander, because of the recklessness. So the prosecution can proceed if the state can demonstrate probable cause exists that the defendant recklessly harmed the bystander. Yes, but it doesn't matter that it was the bystander. It matters that it was reckless. The result is in line with most states that have addressed the innocent bystander issue. Again, the standard, well-established legal doctrine here is if the use of force against the intended target was lawful, the fact that a bystander got injured, unfortunate, but also lawful. If the use of force against the intended target was not lawful, then the injury to the bystander was not lawful. It's very straightforward, not new law, should not be this confusing to a Kansas Supreme Court or any court. So then they have this very long paragraph where they cite from other states. They just organize this alphabetically. Alabama, Arizona, Arkansas, Delaware, Hawaii. They just kind of worked their way through. Obviously, they had a clerk get on Lexis and look all this stuff up. But it's all the same principle I just described to you. In 15 states and DC, there's no explicit statute on the subject and no case law. But even where there's no statute and case law, there's still the well-established legal doctrines I've shared with all of you. So they go through these other states, California, Colorado, blah, 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 blah. It's not the law. It's not known in those states, folks. It doesn't appear yet in case law or statute. But the legal principle is the same and applies everywhere. Apparently, there's one Pennsylvania decision that would have decided to judicially extend self-defense immunity beyond our explicit terms, even where the use of force was reckless. Now, this is an interesting fact pattern. I'm going to have to look this case up separately. In that case, the defendant drew his gun in a crowded nightclub in self-defense. He randomly fired 7 to 11 shots into the crowd after being blinded by pepper spray in the initial attack. He killed an assailant and wounded another attacker. So far, so good. But he also shot an innocent bystander. A court majority, and that looks like an appellate court decision in Pennsylvania. A court majority held the defendant could not be criminally liable for reckless endangerment or aggravated assault for shooting the bystander. I'd really like to see the facts of that case. So there may be good reasoning behind that. I'd have to read the actual decision rather than this paraphrase of the decision. But can we see there would be an argument to be made for reckless use of the gun there? You've been blinded by pepper spray. That doesn't mean you don't have a legal privilege to defend yourself against your attackers, maybe even defend yourself with deadly force. But if you're discharging a gun while you're blinded and cannot direct the fire at your attackers and hit a bystander, was that a reckless use of force? You know it's a crowded environment. You know there's innocent people. You can be virtually certain that every round you fire is going to hit a human being, and probably not your 2 attackers when there's many dozens of other people in that nightclub. Now, I think a finder of fact could go either way, but there's certainly an argument for recklessness to be made there. There was a dissent in that Pennsylvania opinion. Interesting. I'll read it. The holding of the majority effectively allows an actor to respond in any manner and with whatever amount of force he chooses, no matter who he injures, so long as he is justified in acting in self-defense with respect to his aggressors. This is a dangerous precedent. Such blanket authority for the use of self-defense defies logic, especially in contemporary society where possession of lethal weapons and confrontations involving them have become all too commonplace. That's just a political sentence. I would throw that away. Under the majority's reasoning, one would be justified and could not be found criminally liable for detonating a hand grenade in a crowded shopping mall in order to defend himself against an attacker. So, very dramatic illustration of a hypothetical case, but one can imagine grounds for an argument of recklessness in that hand grenade scenario. And again, if the use of force is reckless, it's not reasonable by definition. If it's not reasonable, it can't be self-defense. Let's see. We find nothing in statutes providing a blanket shield for reckless conduct. There ought be no shield for reckless conduct. Here the court does it again. It conflates recklessness with the innocent bystander issue. We find nothing in the statutes providing a blanket shield for reckless conduct injuring an innocent bystander. Well, there should be no immunity shield for reckless conduct, period. Because if it was reckless, it was not reasonable. If it was not reasonable, it's not self-defense. If it's not self-defense, it can't be the basis for self-defense immunity, whether we're talking about the intended target or a bystander. The issue is recklessness, not the bystander issue. But all you'll see in the headlines about the story, folks, is the bystander issue, which is incorrect. But I understand now why the media is spending so much time talking about the bystander issue. It's not just because they're incompetent, which is normal for the news media reporting on legal issues. It's because the Kansas Supreme Court placed that emphasis there wrongly, in my humble opinion. So the judgment of the Court of Appeals affirming the district court is reversed. So in other words, the district court is the trial court. They granted immunity. The Court of Appeals affirmed the grant of immunity, so the immunity was the correct decision, or at least they deferred to the trial court in granting it. And now the Kansas Supreme Court says, no. We reverse the Court of Appeals. We reverse the affirmation of the grant of immunity. We reverse the district court's grant of immunity, and the case is remanded to the district court for further proceedings. So they're not saying, frankly, now it's an open question. Can this officer demand a new self-defense immunity hearing with different arguments to be made under the legal framework consistent with the legal argument presented here by the Kansas Supreme Court? I would think so. I would think essentially the previous self-defense immunity hearing has just been canceled out and you start all over again, rather than having now to go straight to trial. Not that and by the way, if you go back to a new self-defense immunity hearing, the cop could still lose. Again, I would argue that he would lose on the technical legal argument that self-defense is not the appropriate legal defense when you're shooting a dog. Self-defense as a legal defense applies to use of force against people, not animals. The legal defense for use of force against animals is the necessity defense, or whatever Kansas happens to call that. I see Kurt is in the background. Sorry, Kurt, just noticed you're there. I'll bring you up in just a moment. And if the appropriate legal defense is the doctrine of necessity, then self-defense immunity is not even on the table, because self-defense immunity cannot be triggered by the doctrine of necessity. You might be successful in arguing necessity, but you'd have to do it at trial, not in a self-defense immunity hearing. Or the trial judge could decide as a factual matter, this conduct was reckless. And again, if it was reckless, it was unreasonable. If it was unreasonable, it can't be self-defense. If it can't be self-defense, it can't be the basis for a grant of immunity. All right, let me bring Kurt up here. Hey, Kurt, how are you? Sorry, don't know how long you were waiting.
No, that's problem. That's my fault for being very, very late. I apologize.
Mm-hmm. Well, I'm just about, I think I've talked myself out.
Yeah. I don't quite follow the logic of the court. Like on the statute, okay, I suppose, but there are common law doctrines here that also seem to apply. And you wouldn't normally think the statute is abrogating the common law unless it's clear to that effect. Usually they kind of sit on top of each other. To my mind, this is all rooted in the idea that the intent follows the bullet. And so whether or not you're framing it in justification because I'm attacking a human attacker, or you're framing it in necessity because I'm attacking a dog that's attacking me, either way, the idea is that I have a privileged use of force, because otherwise my use of force is illegal, but my use of force is privileged, either under a justification or necessity theory or whatever the case might be.
But in both cases, it would have to be a reasonable use of force, a non.
Well, yes, in the first instance, I would agree with you. Yes, in the first instance,
and that's the difficulty here, because the officer was charged with a criminal charge based on recklessness.
Yeah, but that's where I'm sort of maybe where I'm breaking down, because it seems that the hazard was unavoidable by any sort of conduct by the officer, because the use of force has to be right now. This is like classic self-defense. The threat is imminent or ongoing, so the threat is right now. My use of force has to be right now. So the fact that this girl or whatever else is nearby is to some degree unavoidable, because like, what am I supposed to do as the officer in the first instance? Like, if we can wind the clock back to when, he's making the decision to fire, what other decision should he have made in that instance that would have sufficiently protected his interests? Assuming that the threat was real in the first place. But that's the premise that I'm granting, because if we're assuming the necessity, we're assuming the justification. So I'm assuming that the threat was real in the first place. So what else was he supposed to do?
Yeah. So if we had a prosecutor Binger in this case,
this is Binger's theory.
Right. He would argue, well, that officer has to allow himself to be killed by the dog before he can injure a little girl in the back of the room. But you don't need to go that far, because you can argue that, sure, the officer had a privilege to use force to defend himself against a dog attack, just not discharge of a gun with a girl in the line of fire. He could have used pepper spray. He could have used a taser. He could have used a knife. He could have used his hands. He had options other than firing rounds in the direction of a young girl down the hall. I'm not saying I buy that argument, but I'm saying that's an argument that could be made. Sure, he had a privilege to use force to defend himself against the attack, but the use of that particular type of force, the discharge of a gun, was reckless under the circumstances when he had arguably alternative.
Yeah, this is the Binger
and those
theory.
Alternatives would not have presented that risk to the girl, right? The risk of death or serious bodily injury.
I'm having the same problem here I had in the theory of Kyle Rittenhouse. Like, if we accept the premise that Kyle Rittenhouse was privileged in his use of force against the people that he was firing at, then it doesn't seem to make sense that he's reckless because other people who are, let's assume, completely innocent bystanders in their own right. Well, I'll accept that premise, but his use of force is privileged against the first person. It's the whole idea of intent follows the bullet. Seems to be like the classic thing that this whole idea is messing up. Because if I intend to murder person A and shoot at them, but actually kill person B, intent follows the bullet, right? My intent to kill person A transfers to person B. But the classic conceit is this is true in self-defense. So if I have a privileged self-defense use against person A, and I shoot at person A, intending to kill them, but my use is privileged, but I miss and hit person B, intent follows the bullet. So even though I wound up killing person B,
no question about that.
Even though I kill person B,
you're
I'm still
justified. But you're only justified in shooting at person A if you do it in a reasonable manner. If you do it in a reckless manner, it's not reasonable.
Well, the fact I hit person B somewhat suggests that they were in the zone of risk at the time.
But
otherwise,
that doesn't mean it was reckless
in the first place.
So reckless requires an unjustified creation of risk. So you may be justified in your creation of risk. But again, this comes down to a finding of fact, right? That somebody, I mean, you can see arguments on both sides. The finder of fact would have to determine whether or not they thought it was reasonable or not. And we do have a complexity here, because this is not an argument being made at trial yet. It's an argument being made at this pre-trial immunity hearing.
No, I'm down for that too. I'm all about pure law. That's fine.
Yep.
Yeah, but at pure law, we just are trying to this is why we make arguments like intent follows the bullet, because I don't need any of those stinking facts in pure law. I just assume whatever facts I need to make the legal argument work, right?
Right. So if the use of the gun was self-defense at all, the legal defense of self-defense. If
Yeah.
it meets those five elements of self-defense with respect to the dog, that covers the injury to the bystander.
That's what I think.
Well-established legal doctrine. That's transferred intent. There's nothing new about that.
That's what I think. But this Kansas Supreme Court decision, at least the way I'm reading it, seems to suggest not that because of the particular statute in play, which seems ridiculous.
The statute doesn't even, they mention the statute, but it doesn't have anything to do with the argument here. It seems like the Kansas Supreme Court is just upset that this young girl got injured.
I understand that too. This reminds me of a decision also from the Kansas Supreme Court several years back at this point, where there was a guy who brandished a firearm in self-defense. He didn't shoot, he merely brandished. And because he merely brandished, he was ultimately ruled to be liable under the statutes. Like, if we assume that he had the privilege of self-defense, but when he pulled out the gun, that was sufficient to scare him away. So he didn't fire. But he's only privileged if he actually fires. It's a bizarre conclusion because it's like, well, once I pull the gun, I have no choice but to fire, even if circumstances or prudence suggest that, I shouldn't. I have to, because Kansas Supreme Court said I'm not in self-defense unless I fired. It's just, the whole thing's bizarre.
And I've seen that argument. I think I saw it in Florida, actually. But sometimes, you get these hyper-aggressive prosecutors who try to find a niche in the law, especially, by the way, the legislature wrote the statute in a way that makes it vulnerable to this kind of argument, where they literally say, the actual use of the gun may be allowed, but not the mere threat of the gun. Is the argument that the prosecution was making, and threatening people with many, many years of prison under felony aggravated assault charges.
So this puts me as the potential self-defense person in a very, very weird situation, because now if I pull the gun, I have no choice but to shoot at you out of my own legal protection, even if I could spare your life and still be safe. Yeah. So this is a bizarre
in Florida. The way they were using this is they were saying, listen, mere display of the gun doesn't qualify as self-defense because you didn't actually use it, but mere display is enough to qualify as felony aggravated assault.
Last time I checked, yes.
And under Florida's mandatory sentencing scheme, the aggravated assault, felony aggravated assault with a weapon was good for a mandatory minimum of 10 years.
Right.
So no discretion in sentencing.
Correct. 10-20 life. Yes, we know.
And that's why 10-20 life. And that's why later the Florida legislature actually removed aggravated assault as one of the constituent crimes for 10-20 life because it was being subject to that abuse.
It seems odd because if I shoot at you, that's murder or attempted murder, and aggravated armed assault seems less bad. But somehow I'm more culpable for the less bad act. This seems very odd in these conclusions. I'm privileged for the more extreme act, but not privileged for the less extreme act, even though the threat to me is the same. And I was able to cause less harm. And the law does tend to like mitigation of risk and mitigation of harm. If you can mitigate harm, this is desirable, but apparently not.
Logically, you would think if you're privileged to actually shoot someone, you're certainly privileged to not shoot them. Right? That's what we would want.
That would be
as a matter of public policy. Right.
As a matter of public policy, that would be a great thing, right? Yeah. If I'm privileged to shoot you, I should be privileged to not shoot you because not shooting you is a superior outcome. You get to live, and that's preferable. So I don't understand.
Let me get through a couple of these super chats. We don't have many today, it looks like, but one from Mandy just says $5. Thank you very much. Says, hello, Branca. Please take care of yourself. We all love you. I am taking care of myself, folks. Down to 196. Can you believe it? 196.
Good for you. Good for you, sir.
Couldn't believe it. That's a clean 20.
That puts you in Wonderland.
That's 26 pounds since this spring. Contrarian 420. Interesting. Oh, $5 super chat. Thank you. Interesting, isn't it? That jurisprudence is the only sector of society which consistently audits cultural reasonableness. Well, reasonableness is not completely arbitrary, or shouldn't be. It has a legal framework. It's, you're basing your conclusion on the application of your powers of reason to evidence. You're making inferences from evidence. It's not supposed to be speculation or imagination or emotionally driven. Of course, at the end of the day, the finding of reasonableness is being made by human beings. You can explain to them, first of all, we have to assume they actually were given the correct legal framework to apply, which may or may not be the case. But even if they were, whether or not they apply it is up to them, especially if we're talking about a jury in deliberations. We never really know how they arrive at their decisions. And Lok Nav Livak, RON 25. That's the currency. What's RON? Republic of It's not Nigeria, is it? Because that's like 5 cents. I'm not sure that's an adequate super chat. All right, Wilson. RON25. Thank you very much. Locknav, he writes, I'd like to see you without a tie to tell us what you really think about the Kansas Supreme Court. Well, I don't have any personal feelings about the Kansas Supreme Court, but I think the reasoning of this decision is hot garbage. This is just bad legal reasoning. And that I always find contemptuous, even when it's just from another lawyer. And it's particularly contemptuous when it's been from people who've been elevated to a state Supreme Court. They went through a lot of filters, folks, to get to that position. And they turn out this hot piece of garbage. That's contemptible. All right, let me see if we have any.
I'd love the Kansas Supreme Court to answer the implicit question of what was this officer supposed to do. They're apparently not going to address or answer that question anyway, because I don't know. They don't want to be found with they actually think through what they're actually saying. Like, okay, what are we saying here exactly?
Okay, so we have a few here from. I do have some thoughts and some other stuff in the news before we close out. And maybe you do, Kurt, as well.
I have thoughts of many things.
Let's see. When I look at my law self-defense membership, Donnie writes, under the common law, the act of shooting was justified and any unintended consequence of the act is excusable on the grounds of misfortune. That could be. That sounds like a reasonable common law argument to me. D says, so if I understand the prosecutor generally won't mention the claim of self-defense to a grand jury, does the grand jury have any recourse to reprimand the prosecutor later? I'm not clear on to what extent the prosecutor has to mention legal defenses at all. I mean, they really generally only tell one side of the story, the prosecution side of the story. The defense ability to provide defense context is extremely limited. I mean, approaching zero. I guess they can try to impeach the state's witnesses if the state has any, but generally all the prosecution is offering to a grand jury is like police report. And that's enough for probable cause to go to trial. That's how you get the rubber stamp from the grand jury. So I wouldn't count on your defense being able to present much, if anything, to a grand jury. Miles Dogs 5150 asks, where can I learn if California follows self-defense grant of immunity rulings for both criminal and civil prosecution? California Penal Code is written in Orwellian doublespeak. Well, fortunately for you, we have law self-defense has a state-specific course on self-defense law for each of the 50 states, including California, where we talk about California self-defense immunity law. If it has it, my recollection is it doesn't have any self-defense immunity law, but I could be mistaken about that. Whatever the case, we cover it in the California specific law of self-defense course, and you can learn more about that at lawofselfdefense.com/state, and then choose whatever states are of interest to you. We have that for every state in the union. Let's see. What else? Donnie, again, writes, the defense of necessity is an affirmative defense. The defense of self-defense is an absolute defense. This would be the reason the defendant would want to claim self-defense. So he's, I hate the phrase affirmative defense because affirmative defense used to have a common technical legal meaning in all 50 states, and it doesn't anymore. So as long as you're having a conversation with people within the jurisdiction of one state, well, then affirmative defense means the same thing to all of you because you're talking within the context of a single state. But the moment you're talking to a group of people from different states, that's not true. Affirmative defense, the phrase means different things in different states. But the point Donnie's getting at here is today in all 50 states, if you raise the legal defense of self-defense, the burden is on the state to disprove self-defense beyond a reasonable doubt. If you raise the legal defense of necessity, it's common for the burden to be on the defense to prove necessity by a preponderance of the evidence. Mm-hmm. So that can be a big difference, right? If you're raising self-defense, it means the defense really just has to maintain some reasonable doubt that it could have been self-defense, and the jury's instructed to acquit. But that same defense under the defense of necessity has to be 51% of the evidence in favor of their legal defense in order to win. So that can definitely should be a factor in deciding which legal defense you raise. And then someone mentions good reasons not to go to pepper spray. I get it. There are good tactical reasons not to try to go to pepper spray as opposed to a gun, but those would be factual questions for a finder of fact, not legal doctrine. All right, so a couple of other things that have come up in the news, a couple of big ones. One, this morning, Ron DeSantis had a big press conference where he fired a state attorney in Florida from their 13th Judicial District. This is highly unusual because those are elected positions under the Florida Constitution. And normally the governors will say they don't have a right to fire an elected politician in their governmental framework. DeSantis is saying, well, the Florida Constitution gives me the authority to remove even elected officials, state officials who are not doing their job, and for a variety of other reasons. I'm not an expert on the Florida Constitution. I'll let other people argue that. And I'm very pleased by the result, by the way. This is one of those prosecutors who simply refused to do their job. I don't know if this particular one got funding from George Soros, but he certainly was following the practice of the Soros-funded prosecutors to basically not prosecute crimes in their jurisdictions, resulting, of course, in huge spikes of criminal activity. And beyond the scope of what you would normally consider prosecutorial discretion. So prosecutorial discretion would provide that a prosecutor might look at an individual case here or an individual case there and decide not to prosecute for any number of factors at their discretion. But these prosecutors are saying, as a matter of policy, we're not prosecuting anybody if what they stole was worth less than $500, or kind of blanket decisions, not on the individual merits of each case, but blanket decisions on putting in place their own.
It's a pretty strong incentive to go steal $490 worth of stuff. I'll bring a calculator.
Which is exactly what's been. So we've all seen these videos of people with a shopping cart in CVS dumping a whole shelf.
Is that pre-tax or post-tax? Is that making sure to get this right?
I know. I always wonder that too. It's I think it's probably pre-tax. But just stealing a shopping cart full of stuff, and everybody just watches them roll out of the store with it. And then everyone's shocked when the CVS closes, the pharmacies close, the grocery stores close, and everyone's living in a food desert. That's how you get to have a food desert, folks, is it's just not worth it to the companies to be there anymore. And I wonder to what extent, because we all know that DeSantis has presidential aspirations, at least I certainly hope that he does. And I believe it was just the day before, George Soros had written an op-ed piece in, I believe, the Wall Street Journal saying, hey, yeah, I've been funding all these rogue prosecutors and I'm going to keep doing it. No one's going to stop me. I'm going to keep funding these prosecutors seeking social justice, blah, 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 blah. And I wonder if DeSantis read that editorial and said, you know what, that provides a good political opportunity for me to make a statement, which is if you do that in my state, I'm going to run you out of town on a rail. So one wonders if this was in part a response to that George Soros op-ed, which would really be an issue for a national political level as opposed to strictly a Florida.
Who can at this point believe announcing a policy like that is a good idea? Do these people not have eyes and see how this has actually worked out in the real world with, as you mentioned, CVS's and Walgreens and other stores closing because they get robbed so much that, it's a little bit harmful to the business bottom line?
We live in a bifurcated world, and the people in that bubble just don't want to believe that's a problem. So they'll read that George Soros stuff. He says, hey, you can have social justice and not have an increase in crime. And they'll be like, yeah, brother, you tell them. And they're just completely blind to the actual reality.
Then you get upset that you live in like food deserts and all the deserts because the businesses don't feel safe to be there. Yeah. It's like, why doesn't the store want to open? Well, reasons why do people generally in this direction?
Yeah, well, why do people in Portland and Minneapolis continue to allow their cities to be dominated by these gangs, these left-wing gangs? Why do they elect mayors and police chiefs that accommodate this criminal activity? These special zones that are set up, these sovereign zones within their cities. I don't know why they do it, but they do it.
I always remarked at Chaz Chop that they kicked out everyone and then immediately instituted the most right-wing authoritarian policies known to man. It's like, we're going to have borders and we're going to have border patrol and we're going to have a fence and we're going to have police and everything. As a woman screaming, any men here who can enforce this, get rid of these guys? I was like, oh, you want police forces? Okay. You have patrols and everything, man. It's like, it's to the most right-wing authoritarian policies known to man. That didn't take very long.
It was funny. It's during DeSantis's press conference today, he had a bunch of other prosecutors and local police chiefs there to speak with him. And one of them was Grady Judd, I think is one of the sheriffs down there. Lots of personality, Grady Judd. He's the kind of sheriff who'll stand up and give a press conference and say, well, that guy didn't want to get shot by my officers. He shouldn't have put himself in a position. They should have shot him more, is what they should have done. He's amazing. But he mentioned, listen, we don't want these prosecutors in Florida because, these are the kind of prosecutors we see in places like Portland where mobs set up Chaz zones or whatever they were called. And says, how long one of those zones would last in my jurisdiction? As long as it took me to drive there from here, that's how long it would last. So yeah, it was that part was indeed very entertaining. And I'll probably do a show on that whole press conference and all those dynamics separately. I did save a recording of it, so maybe I'll do a step-by-step through that press conference. It's about an hour long, so it'd probably make for a good 2 or 3 hours of content. Maybe next week. The other thing that happened just later today, of course, was the Department of Justice under Merrick Garland decided to go after the officers involved in the Breonna Taylor shooting, claiming that they lied in order to get their search warrant or arrest warrant.
I'm not quite sure how we're selling that based on the coverage that Nate Brody did so well on this issue. I was talking to him about it earlier today, because they seem to have some pretty good evidence that Breonna Taylor's house was being used as some sort of drug pass-through based on the reporting that's available. So either the Department of Justice knows something that I don't know, or this is BS.
Yeah, so I've been asked by the website Legal Insurrection to write about this, and I'm reluctant to write about it until I see something concrete. I mean, what Merrick Garland says to the cameras is worthless to me, but what is it exactly that the Department of Justice is claiming? Because they're claiming, in essence, that the officers lied to get the warrant, and then they conspired after the fact to, orchestrate a story. All of that would be unlawful, of course. But where's the actual evidence that any of this happened? I'd love to see that. And then, of course, you have the arguably tenuous connection between any of that and the actual. How would that make the shooting of Breonna Taylor unlawful when they were firing back at Breonna Taylor's boyfriend, who was sending shots in their direction? It's I'd like to see that argument by the DOJ fleshed out in more detail, so I have something more concrete to respond to. And frankly, I can't help but wonder if there's not a political motivation here, because just earlier in the day, or maybe yesterday, we heard that the WNBA basketball player who'd been arrested in Russia for drugs was convicted and sentenced to 9 years. We'd heard that the Biden administration, in its everlasting competency in all things, effed up their efforts to get her out of there, which they certainly could have orchestrated. I don't think they should have orchestrated it. Don't get me wrong. I don't think that's in America's public interest. I think we have no interest in her. She's just smuggled drugs into a country and got caught. That's on her. But, Biden administration would disagree. They'd want to pull strings or orchestrate some kind of deal so they could say they saved her, right? A young black woman in the clutches of Russia, of Putin. And I'm wondering to what extent their embarrassment in fumbling their efforts to get her out of Russia, they're attempting to distract / make up for that by pursuing now renewed justice on behalf of another young black woman, Breonna Taylor.
Oh, I don't know. I don't know that there's really much of a connection between the two, although I could be naive about such things. I think the DOJ just saw two convenient political targets and, made decisions independently. But maybe there's a bigger connection between the two.
All right. Anything on your mind, Kurt? You want to mention anything? You want to plug anything? Plug your channel at least, right?
Yes. Well, as it happens, I do have a video discussing the arrest of the female basketball player from earlier today. I did a live stream regarding that, so you can check that out. I also had a live stream earlier going over some of the Johnny Depp, Amber Heard stuff, including Johnny Depp's financials, which were disclosed in detail. So we now know exactly how much he was making from various deals. And some of the deals weren't as good as others. I didn't appreciate the part on one of them where the residual was 3 cents.
My wife just bought me a bottle of Sauvage, which is the perfume he sponsors.
Yes.
I'm wearing it at the moment, actually.
Yes. It is a good one. I've used it myself as well. It is one of the blue series of colognes, as they say. It's a bit aggressive, metallic, high ambroxan content, lasts all day. It will definitely it's clean smelling, gets attention. It is a fantastic choice. At the moment, I am going with YSL's Y EDP, which has some more fruity notes. But yes, it is a classic choice.
So what's he make from that? I mean, is he making like a couple $100,000 a week just from his Sauvage endorsement?
Well, in the past couple of years, he made, I'm going to quote the number, he made like 6.4 million one year. He made 4 million one year. He made 3 million one year. He made like 2 and change for part of 2020, which, was a bad disaster year because of the whole economy thing. But yeah, he was making
not bad.
Several $1 million a year just from the Dior deal. So it was not bad.
Hey, Sauvage, I'm available for promotion.
And Yves Saint Laurent, if you're available, I love your cologne Y. It's fantastic.
All right.
So
Kurt,
yeah, check
well,
out
thanks.
those things on my channel, and don't forget to check out and subscribe to Uncivil Law.
All right. Well, thanks for joining me, Kurt. I appreciate it. No, you're always welcome. So just let me know if you ever. I'm bad about inviting people because I never know who might be available or not. But if you're ever available and would like to come on, just let me know. Happy to send you a guest link. It's as far as I'm concerned, always more informative and entertaining for my audience when you and other of the law tubers are on. It's always great. So I much appreciate you taking the time to be here. And with that, I'll just remind everybody that if you carry a gun, so you're hard to kill, which is why I carry a gun, so I'm hard to kill, so my family is hard to kill. Don't know about Kurt's practices. That's up to him, but he is in Texas. Then you also owe it to your family to make sure you know the law, so you're hard to convict. Until next time, this is Kurt from Uncivil Law. I am Attorney Andrew Branca from Law of Self-Defense. Stay safe.